Hello, everybody. Luis Baez here with my partner Brian Foley at Galveston Criminal Defense Attorneys. I wanted to go over a couple of things about driving while intoxicated cases in the Galveston area, but of course, this might be applicable to other counties as well. But Brian, I wanted to ask you, when it comes to driving while intoxicated charges, what are some of the common issues that you see right from the very start of a case?
I think the first issue at the beginning of a case is we're going to get a call from somebody, either a loved one or the person themselves who was arrested, and this is like pretty much the worst day that they've ever had. They went to jail, they were arrested, or they got in a wreck, they were in the hospital and got out. Now they think they've been told by a police officer they've got a warrant. That one might be worse, the warrant, because they haven't even been arrested yet, and we're going to have to walk them through that. And the fear of getting taken into jail is sometimes worse than actually getting taken in. Um, so somebody at the very beginning of a case, it's dealing with the emotion of somebody who's just had the worst day of their life.
Mm.
If they're a young person, they feel
Yeah,
like their life is over. We represented medical students before, nurses,
yeah,
teachers, uh, doctors, you know, all sorts of people who have a lot to lose, and that our society is not extremely forgiving for things like a DWI conviction, probably less forgiving than it should be. But I think that's the first thing we address is how do we talk to our client and let them know, well, we can help. There's a lot of cases that, even if you got a breath test, even if you got a blood test, there's ways that we can avoid a felony conviction. If it was a felony case, there's ways that we can avoid jail time. You're not guaranteed to go back to jail just because they think you were in fact intoxicated. And then we get cases where it's a really, really close call, or they're just not guilty, and we win a lot of cases like that. So I think that's probably the first thing we deal with is just managing the client's expectation of how bad things can be. And can we help? Yeah, we can help a lot of cases.
Yeah, I think that's a pretty good overview of like what we're dealing with in terms of clients and getting ready to handle a case, like before the first court date for a DWI. One thing that I wanted to ask you, maybe this is part of why sometimes clients are very worried about their DWI charge at the beginning of the case is, if you drive up and down 45, you're going from Galveston to Houston or Houston to the Conroe area, you'll often see these billboards. And these billboards will say things like, hey, don't get arrested for DWI. If you do, it could cost you up to $10,000. Have you ever seen billboards like that? Do you know what I'm talking about?
Yeah, it's DWI. You can't afford it.
Yeah.
Things like that. I mean, it can be pretty expensive. There's fees for, let's take a first time DWI.
Yes, I wanted you to walk us through like how is it or where are they getting these numbers from to kind of
Yeah.
scare the public on the billboards and everything.
So, do you want to confirm the billboards, or you want to
Yeah, I mean I
start
can.
there? Because you could kind of argue it either way. If we get your case dismissed, there's a lot of fees you're going to save.
Right,
There's a
right.
state traffic fine for a first time DWI. If you have a
Oh
conviction,
yeah,
$1,000. They
yeah,
used to have surcharges, but they got rid of the surcharge and they replaced them with what they call the state traffic fine, which is the same as a surcharge. But
yeah.
first time DWI, no prior convictions. If you have a conviction, let's say you want to pay a $500 or $1,000 fine to take care of your DWI. There's some counties that'll do that, and but it's going to result in this DWI state traffic fine. You can apply for indigency, but if you've hired an attorney, they may not allow you to do that. Um, I mean, if you don't hire an attorney, you're going to get stuck with a court-appointed attorney. I don't think anybody wants that either. But in any case, there's a $3,000 state traffic fine. It's higher than that if you have greater than a 0.15 alcohol result. If your attorney fees, it's going to vary case by case. If you don't have any priors, it's going to be a lower fee. But it could get up there. You're going to be between court costs. If you have to have the interlock device in your car, let's say you got arrested, you had a greater than 0.15 alcohol concentration. Well, the court may decide you need to put an interlock device, which is a device that you blow into, kind of like a breathalyzer machine. It goes in your car, and your car won't start unless you blow into it and blow all zeros, no alcohol. If you
Yeah.
just had mouthwash in your mouth that morning and blow into it and you haven't let enough time go by, bing, you might get a notice there. The bond itself, you may get a PR bond on a DWI first, but if it's a DWI third, a felony, you could have a $10,000 bond just on to bond you out. So it could be a lot more than that, you know. Uh, but in situations where uh, you do probation for some period of time,
Yeah, I was going to ask you about that.
you're not automatically going to have the state traffic fine. Uh,
But even
you can
something
also,
like probation has monthly fees while you're on the probation. The device you mentioned, I think, also has like an installation fee. There might also be monthly fees associated with that. So I think your point earlier is well taken. Yeah.
fees. But if you can retain good counsel, we can find ways around those things. But I'll tell you what most of our clients tell us,
Mhm.
is I'm worried about my record. Whatever the fee is, I'll pay it. I got to have this taken care of. I cannot go back to jail. And for, 90 something percent of our clients, they're not going to go back to jail. There's a few instances on felony cases where sometimes it's unavoidable, and nobody's perfect and nobody's a perfect attorney out there. But for most of our cases and almost 100% of our misdemeanor cases, we're going to be keeping them out of jail. We're going to be avoiding a situation where they could never get a non-disclosure. DWI is one of the few cases that even if you have a conviction, you can still get it non-disclosed, assuming you don't get any new ones, assuming there was nobody in a wreck with you involved, even a passenger, and assuming you didn't have over a 0.15. But as you can see, how many minutes are we? We're like 7 minutes into this video, and there are so many nuanced topics. We've talked about state traffic fines, non-disclosure laws, differences if your blood test is a certain level or not. You can see it's definitely not something you want to try to deal with alone.
Yeah, definitely. You mentioned a couple of other things that I just wanted to keep talking about and see what you thought. You mentioned DWIs can be felonies, and then you also mentioned a breath test and a blood test. So, backing up a little bit, what's a situation or how does it take the process from being a misdemeanor DWI to becoming a felony charge? What does that normally look like?
Yeah, so there's a few different types of felony DWIs, I would call them. The first kind, the lowest level felony DWI, is called DWI with a child. And so if you have a child under 15 in the car with you at the time of a DWI, even if it's your first time ever getting arrested, that one's automatically going to be a state jail felony level. That means the punishment range is between 180 days and 2 years in a state jail facility, up to 5 years of probation, up to a $10,000 fine. And so that is one of the tougher cases to deal with, because you're dealing with a person who has never had any criminal history. They're a parent. 9 times out of 10, it's the parent of the child, and they're in this situation where all of a sudden there's no such thing as deferred adjudication probation for felony DWIs.
Yeah.
It's just straight to a felony conviction if we can't find a way to get the prosecutor to either dismiss the case because there's a legal issue with the search or the stop, or to reduce it based on mitigating evidence. So anytime we have a case like that, we start with mitigating evidence. The other DWIs that are felonies, the next highest one you could get is what we call a DWI third or more. If you have 2 prior DWI convictions, even if they were on the same day, like maybe you got arrested twice in a month, and before you were found guilty on the first one, you picked up the second one, you could be found guilty and convicted on both of them on the same day, and you would still, your next one is your third. And so that's a little difference from some sequencing prior rules that they have for punishment, which we could get into later, but that's probably a whole nother video.
Yeah.
But so a DWI third means 2 prior convictions. It could be from other states, it could be from multiple different counties, and it can be more than 10 years ago. There used to be a rule that it had to be within the last 10 years, and some people, I don't know if they're counting on that or not, but that's not the law anymore. You can have it as far back. We've had people enhanced with convictions from the 70s and 80s
Yeah.
nowadays. So it's not that that's not going to matter or that it couldn't be used as mitigating evidence how long it's been, but technically any third or more conviction is a third degree felony. It's 2 to 10 years in prison, up to a $10,000 fine, or 10 years of probation. And again, there's no deferred adjudication probation, meaning you can't avoid the felony conviction. If you take probation on that, you are a convicted felon that first time.
Yeah, wow. And then there's also the other felonies. I think like intoxication, assault, intoxication, manslaughter. So for those who aren't really familiar with district attorneys' offices and how they're organized and everything like that, correct me if I'm wrong, but I feel like at one point you and I both were on the vehicular crimes team for the district attorney's office.
Time?
Not at the same time, but we were both
both
on it.
on it.
Yeah.
I was a little bit older.
Right.
You
No, we don't use the word older. We just right. It's not older, just more experienced. Yeah.
Yeah, we were both prior vehicular crime prosecutors, meaning the specialized team that focuses on DWIs that involve serious bodily injury or death. So intox assault, intox manslaughter. We would go out to the scene of these. Do you have a specific question on that?
Yeah, I was just going to ask. Whenever you got, I think the terminology we would use is we got called out. We were on call. If something happened, we're called out to a scene. So if you got called out to a scene as a part of the vehicular crimes team, and let's say we knew it was a intoxication related sort of offense, what exactly did you do, or what do you remember doing while you were on scene?
Well, there's a lot of different types of evidence in a DWI. They're some of the most complicated crimes because, especially in a vehicular crimes case like that, you've got accident reconstruction, tire marks, yaw marks, impact point. You're trying to identify all these things and try to see if you have enough officers on scene that have the proper training to even investigate this. If all you have are, I don't want to call it any specific agencies, but if all you have are like a smaller police force that doesn't have a designated vehicular crimes group, if you don't have a DPS trooper that's certified in accident reconstruction, like you need to get one on scene, or you're going to lose valuable evidence. On this side of things, defending folks, that can be something that we use. We kind of know what they were supposed to do. Oftentimes they don't do it. They do not investigate every case to the fullest extent, even though the burden of beyond a reasonable doubt requires them to. So, we'd be looking at things like that. We would go try to find security video from if there was a gas station nearby, the wreck, wherever it occurred. If we found receipts in the person's pocket from a bar, we'd go back to that bar. We'd send an investigator there to go download the video there, because these security camera videos, they go away quick.
They do.
Sometimes they're recorded over in 24 hours and they're gone by the next day. So even if you were somewhat diligent.
Yeah, and typically it's like gas stations, shopping centers, nearby stores, stuff like that, where you're just trying to get a lay of the land, and then from there, hopefully find something in terms of surveillance footage or something like that. And we've definitely done that for some of our clients in the Galveston area, where if it starts off like a regular DWI, but maybe they're trying to consider enhancing it or making it a felony rather, we got to go get the video. And that's just something that I think we have taken with us from our time on, vehicular crimes teams. Another thing I wanted to ask you about was drafting warrants and like reviewing warrants and stuff like that, specifically for driving while intoxicated related cases. Did you ever have to do that while you were a prosecutor?
Yeah, I know this is an interview for everybody. But can you imagine? Like, I don't know how many warrants we drafted on that team, but it's a lot. There was always fun. You're having to wake up a judge in the middle of the night and be like, "Hey, judge, I just need you to review this warrant." It was easier when somebody was hurt because, like, "Hey, judge, somebody was hurt. We need you to review a warrant." It was a very different phone call at 3 a.m. than, "Hey, somebody was pulled over for speeding. They're 19 years old and never had a prior DWI. Could we get a warrant on this, judge?"
Right.
There are some prosecutors who just don't even bother waking up the judge late at night. If you have like a weekday refusal or something like that, but. Yeah, definitely a lot of warrants. We always used form warrants that spell it out easily enough where you're including the probable cause, the reason for the belief that the person was even driving. We call that wheeling the defendant, putting them behind the wheel. That's sometimes the hardest part of a warrant, is making sure you've put a valid reason for the traffic stop. One thing I've seen in warrants that we can use, and it happens in just the review of the case in general, is this failure to maintain a single lane. If the only reason that you were pulled over was failure to maintain a single lane, they have to prove that it was not just that you failed to maintain the lane, but you did it in a way that was dangerous. And so if they don't do that, or that's not in the warrant, then it could be something that's used to get the case dismissed or reject the warrant, because that's, the Court of Criminal Appeals has ruled that that's not enough. It's got to be both failure to maintain the lane and in a dangerous way.
Yeah. And, looking back on my time as a vehicular crimes prosecutor, being a part of that team, one of my favorite might be the wrong word, but maybe the thing that I remember the most was actually being in the jail from 10 p.m. to 4 a.m., helping law enforcement with the warrants, but also seeing the different medical staff that would be a part of this whole blood draw procedure and the blood draw warrants and everything like that. And that too, like you were saying with the issue, you start off with maybe one of the issues is a reason for the stop. And then another issue that could be a part of the case is, how that whole procedure is done, whether it's done up to scientifically admissible standards in court. So we had that process where we had been out on scenes, but also the other side of that coin, at least this is how I would describe it, is being then in the jail to follow up with some of the evidence directly from the client. Anything that you remember or feel like is worth mentioning? We talked about stop issues. Have you seen in any of your cases now as a defense attorney issues with blood and nurses, and even where, the condition of the place where the blood is drawn? Anything like that matter at all?
Yeah. I mean, I think when you're looking at blood samples, the key issue here is reliability in the process that was used to obtain the sample. Because if you don't have a reliable method, if you don't have sanitary conditions, then the blood sample and the result from DPS or Houston Crime Lab or wherever it's been analyzed is going to not be reliable either. You're supposed to use a betadine swab, not an alcohol swab. You're supposed to start at the middle of the draw site in concentric circles going outwards. The reason for that is you're not trying to smear around any contaminants. There's things called Candida albicans, which there have been tests that show that a Candida albicans can produce alcohol in a blood sample if left alone for a certain period of time. And we both know that blood turns green after a while when it gets held. I don't know if that's a refrigeration issue or what. We still don't know what that issue is, but we know that sometimes these samples turn green, and the state will still prosecute these cases. So, trying to make sure that those things are done correctly is part of the analysis job for a defense attorney too.
Did you know what a Candida albicans was before you became a prosecutor?
I don't think it's 10 people who know what that is before they become a prosecutor, but it's basically a microbe that can produce, because alcohol is fermented.
Right.
Basically, you could have they do it in jail. They'll take just about any fruit or something like that, and you can make jail wine by fermenting alcohol. And the same is true for a blood sample. It can increase the alcohol level in there. And so when they're testing, people don't even know when they're testing your blood sample, they're not actually testing the blood. They're testing the air above the blood in a tube that's pipetted by a single DPS analyst. And they will test 50 or 60 of these samples at a time. And they'll do that all day, every day for years. By the time they get to trial on your case, they'll have done 2 million samples or something like that. And if you ask them, how many times have you made a mistake pipetting? They'll tell you 0.
Right.
Out of 2 million. And we know that can't, there's no way that that's correct, but that's the way that these things are being done. So that's why it's important to have an attorney that can look at things and say, well, here's the reason why in this case we might want to take a closer look. If you don't have proof beyond a reasonable doubt that this blood sample is correct, and this person does not look intoxicated on video, then you may not be able to prove the case.
Yeah, and it's one of those things where I had never heard of Candida albicans until I became a prosecutor, in the misdemeanor courts. I think my first maybe 5 trials were all driving while intoxicated charges. And I mean, you're totally right. I think we did a good job while we were in the same court of looking at the cases from a prosecutor's perspective, but also from the defense attorney perspective. And I remember handling my first few cases and seeing the blood alcohol report and thinking, okay, hey, it says right here above the legal limit. That's it, right? Can I just submit this document and turn it in and say guilty? And it actually turns out that no, it's not that straightforward at all.
No.
And then the same thing for breath tests too, right? I mean, you were talking about blood just now. What about like breath tests?
I think for breath tests, it's a similar process where they're creating a sample, they actually are testing your breath in that sense, but what is your breath?
Right.
What does that really mean? So what they're doing is they will ask you to blow into this instrument called the Intoxilizer 9000, and it's, to me, I always thought it was a funny name. They started as the Intoxilizer 5000 when I first started. Now they're up to 9. But they'll make you blow into this tube until you're basically out of breath, because they're trying to get the deep lung breath, which is called alveolar breath. I always called it A breath, because who can say alveolar that many times in a row without screwing it up? So they get this really deep lung breath where supposedly the alcohol is mixing with your breath, and then they get a result. But we know from comparatives between blood tests and breath tests that they're almost never the same. They almost never get the exact same result from a breath or a blood test. So using them, I don't know if I agree that they're as scientifically reliable as they should be to be used in court. I think people can think about it like this. If you go to the doctor and they're trying to figure out if you have cancer, they give you a blood test.
Right. Yeah.
Nobody's ever asked you, hey, blow into this. Let's see if you need chemo or not. No, you're good.
Right.
You blew into the machine. It said no. You're fine. Yeah. It's not something people are used to seeing. So I feel like juries are rightfully a little more skeptical of breath tests.
Yeah, and I think for anyone listening, if you're interested in reading more about breath tests and why there are genuine scientific reasons to be skeptical of breath test results, there was a famous article from the New York Times that came out maybe like 5 or 6 years ago at this point. But if you Google New York Times breath test DWI or something like that, the article should pop up, and it really was. I don't know if
we'll put it in the description.
Yeah, I don't know if the word expose is appropriate, but that's just kind of what comes to mind, where it's like a total like inside and out explanation of possible issues. We'll put it that way with breath test devices and everything. And then really the one last thing I wanted to ask you about in terms of breath tests and everything is, we'll have clients when they call us, they'll say, yeah, I did a breath test and I passed it, or yeah, I did a breath test and the cop told me if I passed it, he would let me go. And, of course they ended up getting arrested. And then we get their case, but it was like, we have blood results, we don't have a breath result. Where's that maybe possible confusion coming from?
Where if somebody did a breath test, but instead we have blood results?
Yeah, or maybe they did both, but they think they did a breath test. It turns out it was actually a blood test case. Like a PBT, I think is what they'll say.
Yeah, so a lot of times an officer, if he's not sure that you're intoxicated and he's like on the fence, a lot of times they'll ask you to blow into what's called a portable breath test or a PBT. That result, and it'll be like a little handheld device. It's like sometimes it looks like a little yellow gun or black, and then you blow into it on the side of the road and not at the jail. It's not like the Intoxilizer 9000. So that result is not admissible in court. The scientific validity of that test is much less than the Intoxilizer. So an officer can't use it. So sometimes they'll even tell you that, I can't use this in court, but I want you to blow into this. Blowing into that is not going to do anything, but if you blow over the limit, he's going to take you in,
Right.
And there's no guarantee that result is going to be the same as a blood test. It's probably not. The PBTs are often higher than what we end up with in the blood result. And so I think if an officer is asking you to blow into a PBT, he's already decided he's going to arrest you, and it doesn't help you to do that. If he was really on the fence and he didn't want to arrest you, he would just not arrest you. And if you refuse the PBT, I think you'd be in better position. He's just looking for that validation from that PBT to just pull the trigger and go ahead and arrest you. So if you truly have had zero alcohol at all, then those PBTs will sometimes be okay with that. If you had any kind of mouthwash beforehand, I wouldn't blow into a PBT. In the morning or something like that, or I don't know, you were getting ready for your date, you swish some scope around in your mouth, I wouldn't blow into it. But we will see sometimes people are like, oh, I took this breath test and then now there's blood. Well, that's because it was a PBT. And then they went ahead and got a search warrant for their blood if they refused to do a blood test.
Yeah. Well, I think that's a pretty good overview of, some of the beginning issues of DWIs, maybe how they mix in or it can become felonies, and then also a good overview of the difference between blood and breath test results. I wanted to thank everybody for listening. Again, this is Luis and Brian at Galveston Criminal Defense Attorneys. If you enjoyed the video, please do us a favor and like and subscribe to the channel. We're usually talking about different issues like this in all sorts of cases. Otherwise, thanks for your time, and we'll see you guys later.